two components different from what Judge Aspin described. It relies on voluntary assistance of counsel that is privately funded or principally privately funded, and which also involves a triage system in which claims are sorted, and there's a strong administrative screening process to try to sort the Michelles with the meritorious claims from the potential plaintiffs without meritorious claims. But in turning to Jim Brosnahan, and Mr. Brosnahan, we've talked so far about two acts of governmental grace. Judge Aspin's grace in the form of creating a mandatory system for lawyers. It's mandatory for those who want to be part of the bar. Judge Matz's system in the Central District, which creates this enormously beneficial program, but neither of them has been described in terms of a right to counsel, not the kind of right to counsel we conceive of for indigent clients in the criminal system. And yet what we've seen in the Michelle video, for example, is a problem of just being unable to afford the resources for private counsel. Do you want to go so far as to argue for a right to civil counsel?
Oh, yes.
No.
Yeah.
Thought you might.
Let me add it, yeah. What I like about this panel is the focus around the clients. And everybody in this hall has, one way or the other, spent their lives worrying about justice, not only the results of cases, but the process. And here is a client who has not read Judge Friendly's book on federal jurisdiction and stood at a lectern and didn't have a lawyer, and then she got a lawyer. The right to counsel movement, and it is a movement, there are thousands of judges and lawyers in the country who are talking about it, thinking about it, writing about it, studying it. But at the heart of it is the image of an unrepresented person standing at the lectern in court. Today, our great interest is in the federal courts, and they do not have a lawyer. I wish that I could gain some of the objectivity that I see some people have in the face of that problem. I don't have any. I think I like lawyering too much. I know what lawyers do. In limine motions, those are good things. I don't think judges like them all that much, but they are an important part. We're going to exclude this on the grounds that that's hearsay. And by the way, we're going to make a record. And when we make a record, if we're not happy with the decision, it'll go to the Ninth Circuit. Occasionally, not often, it'll go to the Supreme Court. And then that'll be decided. If there's no record, it won't go there. 70 to 80% of the people who go to court in the United States do so without a lawyer. 35% of those people are facing a lawyer. In state court, some of those folks are fighting to maintain the relationship between themselves and their child, or their house from which they will be evicted, or spousal abuse of some kind on the civil side of things. And what I would like to do very briefly is just give you 10, not so much solutions, but thoughts of things that the folks who are working, and we have a commission in California. Judge Andy Guilford is here from Orange County. He's on our commission, and his presence there represents a new emphasis on the federal side of things. And so what I want to do is go through, and some of these things I think are immediate. Some of them you could do, speaking to the district judges, and perhaps even to the appellate judges, you could do on Monday. The first one is, and you've heard examples of this, and I've talked to some judges here this week, appoint a lawyer to represent an unrepresented person. On April the 7th, 1962, Lester Buatti murdered Alice Saccotti on the Navajo Reservation in Arizona. And when he stood at the lectern, I was standing next to him as a federal prosecutor. Judge Ling, of sainted memory, who loved to be with all of the predecessors of you folks, and was quite a raconteur and wonderful, actually a mentor to some of us who were young kids, looked down at a civil litigant who had come to argue some motion and said, Felton Beck, you're going to represent Lester Buatti. First-degree murder, death penalty, still possible. And Felton Beck came up to the lectern, and I turned around and looked at him, and I thought to myself, he's too young. I was 28. So as I think about this story, two things are obvious. I don't know how old he was, but I was full of myself. It's like, he lost the trial, but he did well in the Ninth Circuit. He did his pro bono. And that was before Gideon. But it troubled me in 1962. And I got some literature. I bought a book. There were lawyers who were studying it. When Gideon hit, it was not the lawyers that made Gideon happen. It wasn't the judges. It wasn't even the ABA convention, although people were talking about the problems and they were writing about it. It was Clarence Gideon, an occasional burglar, petty burglar, not an accomplished burglar, not a really good burglar. A petty burglar who had nothing to do wrote a letter to the Supreme Court and said, if you don't mind, I think I got a right to a lawyer. So why can't the federal judges appoint people to represent the unrepresented? In appropriate cases, there's a world of analysis we don't have time for, what's appropriate. I'll come back to that in a minute. Why can't that happen? There are commissions in half the states that would be anxious, I think, to hear how the federal courts want to do it. There are bar associations that might be helpful. There are complex resistance problems here or there, but as you heard in Chicago, those have been overcome. So that's number one. Number two, everywhere it is discussed to increase pro bono. 5% tithing of the representation of poor people I've always thought was a good idea. It's been proposed. It's a good thing, and it is true. And they asked me to mention this, not that this group needs it. The lawyers here do their pro bono, but the enrichment of your, not only your practice, your understanding of what's going on in the world, but the enrichment of your professional life, it can be tremendous, can be enormous. The psychological difficulties of the unrepresented are a serious deterrent to all this, but they can have legal problems, and the solutions of them can be very good. We did a budget to see if California was properly funded and everybody who should be represented, that's another one of these very important qualifications, was represented, what would it cost? And we had a pro bono, a very difficult analysis, by the way. I'm not satisfied that we got the right answer, but we had an answer, the pro bono part of it. What does that do? That shows the public the lawyers are doing all this work, and they are. And it should be public that we do this kind of work. Third, there are commissions that are doing all kinds of things. One of them is self-help. And I came to this very slowly. It doesn't sound right. It's a little bit of a helping thing that's done. The people that do it are the best people in the whole world. Many are lawyers, and they're in the courthouse, and they kind of help the unrepresented. If you can't do anything else in September, then a self-help program is certainly good. There's unbundling being discussed. Moving away from the conventional, Your Honor, I'm appearing. Once you're in, I can't get out unless Your Honor says I can, or some rule says I can, or they didn't pay me, which is, unforgivable, really. I digress. But it just came into my mind. I don't know. But unbundling is you could have a lawyer for the settlement conference, or you can have a lawyer for, this argument or something. Number 4, the Shriver Act in California has been much discussed. It's called the Shriver Act because the wife of the governor is Mrs. Shriver. And our chief, he's just now retiring, it's just fabulous, Chief George. And Ron George, and he went to the governor and he said, we're going to do this program. We're going to call it the Shriver Program. And the governor said, you are a hard bargainer because it's being paid for out of court fees. It's an experiment. It'll be in 3 counties. They're working on it as I'm out here enjoying this beautiful place. And it's an experiment to see whether representation can be done that way. Fifth is one answer to the question I was put a moment ago. We're going to change the law. Perhaps a state will hold there's a right to counsel. We did a mock argument about 3 months ago, we being the little San Francisco Bar Committee I'm co-chair of, and we had 2 former members of the California Supreme Court. We wrote briefs, and we said that the law in California allows right to counsel in certain cases. We created a mock mother who hadn't lost all of her control of her child, but had lost quite a bit of it. And then we had a mock argument, and then we watched the judges debate. It was very interesting. It satisfied me that in California there may be an existing right to counsel. Some state may do it. Federally, there's a case called Lassiter, which holds, in my view, that there is a right to counsel in civil cases, but it's limited, first of all, to the trial judge has to decide it's necessary. This sounds a little bit like pre-Gideon. There was a case before Gideon that was kind of like that. You know, if it's complex, then maybe you need a lawyer and that kind of thing. But it's also limited to cases that are fairly close to some criminal aspect, some penal aspect. So it's a very limited case. It's 1981. The mother in that case will get no telephone calls on Mother's Day, as described in the record. And this is, you know, that if you have a trial lawyer on the panel, this is the kind of thing I think of. Yeah, it reads terribly in the record, but she didn't have a lawyer. I mean, how would it read if she had a lawyer? Would it be any better? Number 7, there are categories that really matter, and 2 of them are where the unrepresented is a defendant. That was mentioned a moment ago. Seems like they should really have a lawyer appointed in those cases. And secondly, where they are against a lawyer. Now, there are many circumstances. It gets very complex, I understand that, but it seems like if they're opposed to a lawyer, that they ought to have a lawyer. Really, my point here is the priorities that would be set as the appointments of lawyers are beginning to be made, and those are reflected in an ABA resolution of '06, which calls for a government-funded right to counsel in 2006, and where the basic human needs are at stake, such as those involving shelter, my house. I'm losing my house. Maybe I don't have a good legal case. In Ireland in 1876, they took away the house from somebody who then had very hard time having anybody in the neighborhood. When the new family moved in, the new family couldn't talk to anybody. Nobody would talk to them. His name was Charles W. Boycott. It's an obscure Irish reference, but I'm almost finished, and I like not to speak on any subject unless I refer to the Irish in some way. And there is something about this for everybody. Look into our own families, go back. How far do you go? How far back do you have to go? Everybody can find somebody. Everybody can find somebody like the unrepresented people in the United States today. Not a problem. Sustenance, safety, health, child custody, and so forth. Some of these are not federal matters. The Legal Services Corporation, the president has asked for $45 million more. I would say in California, the heroes and heroines that do this work are able to do perhaps 15% of the need in the state of California. And they would be doing more federal cases if they had more money. The timing of this is not good, but the planning would be, when the recession is over, to up that amount of money. Number 9.
Jim?
Yes.
Whenever I hear a reference to the Irish, I get a little nervous
Yes,
that we
thank
might be
you.
going over our time. So
Yes,
I just wonder
okay.
if we could,
All right, then
could
I will-
possibly speed
I
it
will-
up to get to the non-Irish
yes.
gentleman on your right.
I agree. I will close with these 2 points. One,
I'm allowed to say that. I'm a Sullivan.
yeah, very good. The Lisbon Treaty was signed on December 1st. 27 nations in Europe adopted, most of them, not all of them, few reserved away from this. Paragraph 47 calls for right to counsel in all civil cases. Europe's doing it. Ireland has done it. I come back to it despite...
Jim?
We have been suppressed, as you well know, long enough.
800 years, but we can't go on that long with the panel.
And finally, perhaps some city will become the first right to counsel city in the United States. How would it be paid for? A tax on law firms. I've heard those words not too long ago. The last question, which I learned years ago to ask on any matter that matters this much, and in the view of, I think, everybody in this room, this really matters. The question is when. When will this be done? There are enormous problems. But if we only see the problems, the answer will be it won't be done, and it's really worth doing. Sorry to go over my time.
Thank you very much, Mr. Brosnahan. You can certainly see why Jim Brosnahan has won all but 11 out of 132 jury trials, and why he is such a great spokesman for the right to representation